There being 32 ayes, 32 noes, the matter is resolved in the negative. If senators would wait, I'll deal next with Senator Ludlam's motion. I don't know if there might be a division here. There will be. All right. Wait a minute. Before I call Senator Ludlam, Senator Joyce.
I seek leave to make a short statement.
Is leave granted? Leave granted for 2 minutes.
Yeah, thank you very much, Mr Deputy President. I think it's very important on this issue, on the Heiner inquiry, which I've been pursuing for quite some time. In fact, in a former time on the backbench, actually bringing the report into the chamber to try and get it tabled, that I express my absolute disgust that we have not seen right to go down a process of getting transparency on this issue. There remains a lady who no one denies was raped, and is still seeking justice on this issue. Beyond all the so-called issues and other things that are dragged into this, that lady deserves justice. She wants her time to be able to explain her position, and we know that she has received money, an amount basically to stay quiet, and I think this is absolutely disgusting. And I have to say it on the record that Senator Fielding, I'm absolutely, as a person who's a patron of the White Balloon Day,
point of order.
to vote against this.
Senator Joyce, Senator Joyce, just resume your seat. Senator Bob Brown.
President, there is a standing order that senators will not reflect on a vote on the Senate, and I ask you to look at what the senators or interject, and I ask you to look at that standing order.
Yes. Reflection means in an unparliamentary way. I'll allow you to continue, Senator Joyce.
Yeah, thank you very much. And I'm also extremely disappointed, Mr President, on the position of the Australian Greens, that they too have become party to try and circumvent the process of transparency. This issue must, at some point in time, be brought to a position of conclusion, a position of transparency. I believe, and I've said before, that this, in a form, is Australia's Watergate, only this time people got away.
A man I know very well and have for many years, Kevin Lindeberg, was central to these calls and has been for a couple of decades now, and joins me this morning. Kevin, good morning.
Good morning, Greg. How are you?
I'm good. This really has been more or less a life quest for you for the last 2 decades, hasn't it?
Well, I lost my job when I was trying to preserve the documents, and I took this matter to the CJC in 1990, and that's where this incredible journey commenced. And I've stuck at the coalface for all that period of time, and by my sticking at the coalface, and then with Bruce Grundy reporting it, we discovered this stuff, this child abuse business that was hidden from the public. Greg, can I just quickly say, that misleading evidence that you talk about by Craig Sherrin was given to the Courier Mail, not to Parliament. So, so that's an important thing as well to remember in this situation.
Okay, let's just go back in time a little bit. And for those new to our city, and there are many, and new to our state, and there are many, and those who have forgotten the details, remind us of the nature of the Heiner inquiry, because we will pursue this, Kevin. We'll just talk about it. We'll chip away at this.
Yes, exactly.
What was it about, and how did it conclude?
Well, in September 1989, incidents of child abuse were reported in the newspaper, in the Sunday Sun at the time. And in fact, it was Anne Warner, who became the Families Minister, who reported this matter and called for an inquiry into the John Oxley Youth Centre, into the management of the centre, which included the abuse of children. So the Cooper government established the inquiry to be led by Noel Heiner, and it was lawfully established under the Public Service Management and Employment Act. And then when then there was an immediate change of government in December after the Fitzgerald inquiry, which brought in the Goss regime. And then in February and March, they shut down the inquiry and shredded all the evidence to prevent it being used in judicial proceedings.
Now, a lot spins on why they did that.
Yes, it does.
What was their rationale, and what do you think about their rationale?
Well, let me tell you, absolutely. There have been untruths told about this. They claim that the inquiry was incorrectly set up. It wasn't set up under a commissions of inquiry, which therefore left the witnesses open to defamation action. Now, that's an untruth, because what they did, while it wasn't established under a commissions of inquiry, they were told that all the witnesses were covered by qualified privilege, but then the Queensland Government actually indemnified all the witnesses and Mr Heiner in February 1990. So the notion that they had to shred the documents to prevent people being sued for defamation is an absolute lie. And of course, having indemnified them, then they shredded the documents to prevent them being used in court proceedings which they knew were about to commence.
What were those court proceedings, Kevin?
Well, the court proceedings were by public servants who wanted to access the documents as they had a right to access the documents by law. And their solicitors, plus myself, because I was a trade union official at the time, and it was my duty to preserve the documents. We served notice on the Queensland Government. We told them not to destroy the documents because they were required for court. And then behind the scenes, involving also the archivists, you mentioned the archivists before, because this has now become one of the great shredding scandals of the world, they shredded the documents while knowing these documents were going to be required for court to prevent them being used in those proceedings. And for years, the CJC and others claimed that the law said you could destroy documents which were known to be required for court proceedings before those court proceedings commenced. And I said that's a load of absolute nonsense. And that's what I fought against. And in fighting against that, Bruce and I found the child abuse.
We'll get to the child abuse in just a moment, but when you made that decision to pursue it, you also made a decision that was going to change your life. And when one person takes on the system, you can write lovely books like The Power of One, and it was a lovely book with fair dinkum. When you take on the system, you've paid a price, haven't you?
Well, it's been a horrendous price. I mean, we didn't... Greg, this is 20 years, mate. I never ever expected to be like this. Little did I know at the time that the Cabinet was actually involved in the thing. And then, of course, I went to the CJC, and it's on the public record. It was mates investigating mates. And they couldn't face it. The barrister said to me at the CJC, Kevin, what? Because I took it to the CJC, I blew the whistle. They said, what do you want me to do, Kevin? Charge the entire Cabinet with criminal conspiracy for perverting the course of justice? And I said, if the law requires it, then it should be done. The CJC then went on and misinterpreted the law and said I was a ratbag because I said the law was being incorrectly interpreted. And then in 2004, they charged the Baptist minister for the same conduct and applied the law correctly, and he was found guilty by a court of law.
Kevin, what did you, and it can be difficult to ascribe motivation to others, but looking back on it, was it simply political motivation on behalf of the Cabinet, do you think?
Well, look, that's an open question, but one of the plain things is this. They have said that they destroyed the documents to prevent them being used in judicial proceedings. Now, that's a criminal offence under Section 129 of the Criminal Code or Section 132, perverting the course of justice. Now, it can be said in one area that it's a bit like what's going on inside the churches, whereby they're only interested in their own image. And they wanted to put forward a perception that they were doing the right thing and so forth. The Cabinet has admitted that they knew when they destroyed the documents, the evidence was about child abuse. And now we found out that part of that child abuse was the pack rape of this girl.
How many counts of child abuse were there? And then we'll talk about this specific case.
Well, there was other instances which went to the Ford inquiry of children being handcuffed to fences and grates through the night out of the centre, which breaches the criminal code. And there was other children being psychologically mistreated. And I mean, in many ways, I caused the Ford inquiry to be set up. But what I said to the Ford inquiry is, you cannot investigate incidents of child abuse without looking into the fact that evidence of that child abuse had been shredded 9 years earlier by the Queensland Government to cover it up. And the Ford inquiry refused to do it.
So how significant then is this recent case about Annette receiving $120,000 approximately, but still wanting to make it a criminal case? Can she? Will she? Should she?
Well, the point about it is nobody's been held to account for those who did the assault, or for those who shredded the evidence that was relevant to that incident. And of course, what we have also going on at the moment is this: you mentioned about a statement of concern that was served on Premier Bligh and Mr. Langbrook. That was signed by 4 judges, and they have said that what's going on inside the Parliamentary Crime and Misconduct Committee is outside the law when the Labor Party members refused to have this matter properly investigated. The point is that Annette's assault is very, very important, but it is one element of this massive cover-up that's been going on for 20 years, which shows that the Fitzgerald process is not working, because at the centre of this is the failure of the CJC and the CMC to come to this matter in an impartial and professional manner.
And as you say, and we often talk about it, it's always the cover-up, isn't it? It's
well,
always
exactly,
the cover-up.
Greg. It was arguably it was a stupid act that they did, and of course there was deception. They weren't, when we were waiting for the documents, they were saying everything's okay, but behind the scenes, Greg, they were destroying them secretly.
So Wayne Goss was Premier, and who else in a position of power?
Well, I mean, it's well known that Mr. Rudd was there as the chief of staff, because you see, we now hold the cabinet documents, and the cabinet documents unequivocally show that when they destroyed the documents, they knew they were required for court proceedings, and that was a Baptist minister has been charged for less knowledge than what they had. And so you've got bureaucrats, senior bureaucrats, and all members sitting around that table who had that knowledge contained in the cabinet submissions, which we hold, which is sufficient to trigger 129 of the Criminal Code at the very least, if not a conspiracy, because there was more than one person involved.
You see, yeah, they destroyed the information. They will have an argument for that, and we can debate that another day. But, you know, it's that old line, isn't all that's required for evil to triumph is for good people to do nothing. And bottom line is they did nothing, and you've spent 20 years trying to do something. What should happen now, Kevin?
Well, look, what must happen? What must happen is the situation relies with the opposition in particular because of what's happened inside the Parliamentary Crime and Misconduct Committee, Greg. Because the way in which the law has been interpreted in there, these judges, like the former Chief Justice of Western Australia who signed that document which was served on the government on the 22nd of June, have said that the way the CMC handled this matter is so serious that unless it's reviewed, it cripples the entire Fitzgerald process. That is because the way they've interpreted the law, both sides of Parliament can cover up their own corruption inside the PCMC. And so they must come back to this issue. It must go to Parliament, and the law must be obeyed. I mean, the point is that if it's good enough for a Baptist minister to be charged for destroying documents before court proceedings commence, I suggest in a democracy that it's also good enough for members in the public service, people who hold positions of trust, to also have the law applied equally.
Even more so, Kevin, isn't it? More so, because, you know, democracy and our freedoms, they reside on and rest on that kind of accountability and responsibility. There's a greater weight there, isn't it, really?
Well, Greg, this is the reason why the Heiner affair is considered to be one of the great shredding scandals of the 20th century. And I don't know whether the people of Queensland know this, but this matter, since 2009, has now entered into Queensland's curriculum in its state schools and being taught as a scandal, because it goes to all the great democratic principles like equality before the law, the right to a fair trial, probity in government. All these issues are wrapped up in the Heiner affair. And I must say, I find it ironic in the extreme that the CMC have recently, and I suspect rightfully, criticised the police who gave a clearance to the police who investigated Sergeant Hurley because of a lack of impartiality and professionalism. The same charge rests on them in respect of how the CMC investigated this matter.
It's a massive double standard.
It is an utter disgrace, and it's in the rope audit, sitting inside the vault of the CMC, covered up by an invalid decision of that committee.
We'll stay in touch, Kevin. Good to talk to you.
Thank you very much, Greg. Goodbye.
Yes, Kevin Lindeberg. It really is one of, as Kevin was saying, it's a case people around the world talk about now, the Heiner affair.